Hi everyone, my name is Dahlia Radcliffe Castillo, and I am an immigration attorney in Fayetteville, North Carolina. Today I want to talk to you about one of the questions that I get asked a lot is whether my citizen child can petition for me. The short answer is yes. However, a lot of times, especially the type of scenario I will see is the answer is no. Under the yes scenario, if the parent came into the U.S. with a visa, like a tourist visa or a H-2B work visa or some kind of, any kind of visa, and then overstayed, and then later on had a child who is now 21 years old, it's really easy. You just have to show that you're parent and child, and the entire process will be done here in the U.S. Now, if the parent came without a visa, the child can file the immigrant visa petition, but what will happen is when the I-130 is approved, it will be transferred to the National Visa Center for consular process outside the U.S. The parent will then have to leave the U.S. to go to his or her consular interview in their country. However, once they depart, then they'll be hit with that 3 to 10 year bar, and they would have to sit outside the U.S. For those periods of time until it's up, and then they'll be able to come back into the U.S. Now, there are exceptions to the rule, but like I said, it depends. If there are waivers to waive the unlawful presence, but the waivers are for people who have permanent resident or U.S. citizen parents or spouse. If you only have a U.S. citizen child, then you will not be able to get the waiver. If the person has a U.S. citizen child, but has, let's say for example, a permanent resident spouse, and the parent can show a hardship on that spouse if they were not permitted back when they go to their interview. If they're able to do that successfully, then that's how it would work. The child can petition and then use the hardship on the permanent resident spouse. The other option would be if the parent is 245I eligible, and 245I is a section in the Immigration Nationality Act, which allows a person who is unlawfully present in the U.S. to get a pass by paying a $1,000 fine. If someone filed a I-130 or an I-140, the I-140 is for work visas. If one of those petitions were filed for them before April 30th, 2000, for example, let's say your mom is from Mexico and she came back in the 90s, and her U.S. citizen brother filed a petition for a green card for her. But if you look at the visa bulletin, you will see that they're only dealing with the application they received in 1993. So you see it's a long time. Here, mom now has a 21-year-old or older child, U.S. citizen child. Mom would just have to pay the $1,000 and then be able to adjust status under the child. And so if mom is eligible for the 245I, then the child will be able to petition for mom and have everything done here in the U.S. The other way is if the child is a member of the armed forces, and that includes the Army, Marine, Navy, Air Force, National Guard, or Reserve. And the child must be either actively serving or if they're no longer in the military, they would have to show that they have been honorably discharged, and that you can find that on the DD 214. And so the parents, will apply for the military parole or PIP, and if they're successful in getting that approved, because it's discretionary, then it would be as if the parent came in lawfully, and so you can adjust status and everything. Everything will be done here in the country, because it would be as if the parent came in lawfully. I hope that answers your question. If you have any other questions, or would like, or if any of these, if you feel like you fall into any one of these categories, please call us and schedule a consultation. My office number is 910-670-7833. I hope to see you. Thank you.